Hello, namaste friends. I'm Mksrinivas here. I'm continuing with my video that is to presenting revocation of offer. Now I have come to case law, that is Dickinson versus Dodds. It has been held in England that it is enough if the offeree knows reliably that the offer has been withdrawn. The facts were the defendant signed and delivered the plaintiff an offer to sell a property at a price fixed and added a postscript saying that this offer to be left open until Friday 9 o'clock a.m. 12th June. A day before of the expiry of this period, the plaintiff was informed by a third person that the property had already been sold to another. However, the plaintiff before 9 a.m. on 12th June found the defendant entering a railway carriage and handed him the notice of acceptance. The court held that this document amounted to only to another offer and which might be withdrawn at any time before the acceptance, and a sale of third person which came to the knowledge of the person to whom the offer was made was an effectual withdrawal of the offer. And added in this case, beyond all the question, the plaintiff knew that Dodds was no longer minded to sell the property to him as a plainly and clearly, as if the Dodds had told him in so many words, "I withdrew the offer." Now, revocation of general offer, where an offer of a general nature is published through newspaper, it can be withdrawn by the same media, and revocation will be effective even if a particular person subsequent to the withdrawal happened to perform its terms in ignorance of the withdrawal. Then superseding proposal by fresh proposal, where before acceptance a proposal is renewed in some parts of it and not in its whole entirety as proposed earlier. Proposal to sell salvage claims in respect of 9 vessels superseded by a subsequent proposal to sell only 4, and the later purports to supersede the earlier communication. Such proposal is no longer available for acceptance. Now, cancellation of allotment of land. An allotment of land was made under the order of a development authority. The allotee, that is the plaintiff, deposited the money and an agreement was signed by the parties. This brought about a concluded contract. A subsequent cancellation of the allotment by the authority was held to be not proper. The court said that the authority was under a binding obligation to approve the building plans for the land. The pendency of a criminal investigation regarding the allotment was held to be no relevance, and this case is called as Rochi's Hotels Private Limited versus Jaipur Development Authority, All India Reporter 2002, Raj 316. Now, revocation of bid. In case of an auction, the assent is signified on the part of the seller by knocking down the hammer. A bid may be retracted before the hammer is down. In Madras case, Payne vs. Cave in 1789, 3-term representation, 148 page, the appellant made a bid at an auction, the highest bid that was made. But before the property was knocked down, he discovered that the property was subject to a mortgage and retracted his bid. But even so, the auctioneer knocked down the property to him. The owner of the property sued him. The court held that the plaintiff's bid was no more than an offer and he was entitled to withdraw the same before it was accepted by the property being knocked down to him by the auctioneer. So now, lapse of time. We'll come to major this one, how a revocation happens. An offer lapses on the expiry of the time, if any, fixed for acceptance. But an offer says that it shall remain open for acceptance to a certain date. It has to be accepted within that date. It has been suggested by the Calcutta High Court that in such a case it is enough that if the acceptor has posted the acceptance before the stipulated time, even if it reaches the offerer after the stipulated time or date. The court said that an effective date on which the option of acceptance is exercised by a party is to be ascertained from the date when the acceptance is put in transmission and the letter is posted. When an application for admission to an institution had to be filled in within the prescribed time limit by sending it either by registered post or in person, the candidate sent it either by registered post or in person, and the candidate sent it by registered post same 4 days before the last day. Then where no time for acceptance is prescribed, the offer has to be accepted within a reasonable time. What is reasonable time will depend upon the facts and circumstances of each case. The definition of a reasonable period is a question of fact depending on the surrounding circumstances in which the agreement was made, where the subject matter of the contract is an article like gold and prices of which rapidly fluctuate in the market. Very short period will be regarded as reasonable, but not so in reference to land. An offer for sale of shares allowed for a month in which accept both parties agreed that a reasonable period in this context would be one that would allow an informed decision as to whether the acceptance was in their best financial interest. The court did not agree with this contention. By failure to accept condition precedent, where an offer is subject to a condition precedent, it lapses if it is accepted without fulfilling the condition. Where a Salt Lake was offered by way of lease deposit some money within a specified period and the intended lessee did not deposit the amount for 3 long years, it was held that this entailed the cancellation of the allotment. State of West Bengal versus Mahendra Chandra Das in 1990 to calculate LJ1. Now, by death of the insanity of the offerer. But an offer lapses on the death or insanity of the offerer, provided that the fact comes to the knowledge of the offeree before he makes his acceptance. In England, it was felt that at one time that an offer terminates at once the death of the offerer, whether or not the fact has come to the notice of the offeree. Mellish LJ, the arbiter in Dickinson and Dodd's case, that an offer cannot be accepted after the death of the offerer, but in an earlier case, where a creditor continued to act on a guarantee without knowledge of the surety's death, the court pointed out that an offer is not necessarily terminated with the death of the offerer. It may remain open until the offerer comes to know of death. There is no provision in the Act about the effect of the death of an offeree, but an offerer can be accepted only by an offeree and not by any other person. It should not be capable of being accepted by the offeree's executor also. Examples are Reynolds versus Atherton, 1921, 125 LT 690 page number. Okay, now section 4 of the communication, 4 of the Contracts Act 1872, communication and complete. The communication of a revocation is complete as against the person who makes it, when it put into course of transmission to the person to whom it is made, so as to be out of the power of the person who makes it, as against the person to whom it is made, when it comes to his knowledge. So communication is very important aspect so far as revocation of offer is concerned. Now I have presenting you a graphical representation showing the timelines of revocation and of offer and acceptance put together. See, A is going to make an offer to B, makes offer, and you see here the main constraint is 10th March 19 makes an offer, A receives offer, B receives offer 12th March 19. So communication of revocation of offer on 11th March is also okay. Receives revocation on 12th March 19. Completion of notice of revocation of offer is having till such time where the time limit to revoke offer I have shown that from 10th of March 19 to 13th March 1 p.m. Now acceptance, post acceptance, receiver A has to receive it, B has to give the acceptance. Time limit of revocation of acceptance is